I thank NLU for having given me this opportunity, not only to speak something about my views on the subject of WhatsApp and PDPB, but also for having given me an opportunity to connect with people like Mr. Gulshan Rai, with whom I have been interacting for last 20 plus years, Rama Vedashri and Professor Sudhir Krishnaswamy, with whom I share at least the city where we stay. Okay, and thanks, Professor Sri Krishna Devarao, whom I came to know only today. Okay, fine. Now, let me thank Professor Sudhir for having brought focus to our discussion, and I would like to quickly go into some of the specific points which he has made. See, we are discussing WhatsApp in the context of the proposed PDPB. Okay, now right now, what we should think of is, I personally think I should thank WhatsApp for having brought this discussion into the open by taking a particular way of expressing their desire to get consent. See, everybody knows that personal data protection legislation is a balancing act between at least three parties. One is the data principal, who wants his privacy to be protected at any cost if possible. Second is the business, which has to actually continue running, and if business doesn't run, we will not be discussing privacy today, we will not be even discussing internet today if perhaps the internet was not available freely for some time back. If Google shuts down or a search engine shuts down, I don't know whether internet will exist and our privacy discussion will exist. So business has to survive. Now the question is whether business can survive without infringing on what individuals think is a right to be protected under human rights. Now the government is in the background. Now government also has got a legitimate interest in protecting the people's privacy. At the same time, they also have a duty to protect other fundamental rights. So see, we cannot say that privacy is the only fundamental right in any country. It is one of the several fundamental rights, and Supreme Court also has to yield to say that a reasonable exception is permissible for privacy. So if I am actually as a citizen want to be secure, so I would like to know whether privacy can be an unbridled say right to be given to anybody else. I want today CCTV footage to be used by the police to take to identify people who plant bombs, etc. So this Personal Data Protection Act has to be considered as an attempt to bring balance between three disparate logics, and that is what is there in the preamble of our PDPB. So it is recognized there. Now, all said and done, what is that we are trying to do in PDPB? We are trying to give a right of self-determination to the data principal, that there is a set of data which we have identified as his personal data. That is data which can be used to identify the individual. So we identify that as the personal data, and we tell him that if you are handing over your personal data to me, who is a technology person, you tell me how I should use it, how I should dispose it, how I should share it. That is all what is required. And if I get that consent, which is definitely a form of limited use, which is the licensing concept, I will be using it only for that purpose. And beyond that purpose, if you want to withdraw the consent, you are welcome to withdraw the consent. So WhatsApp has done what it has done now is to ask for that consent. You can ask me why they did not ask this consent 3 years back, 5 years back. We don't know. But right now they are asking for the consent. We have to look at the fact whether the consent has been fairly asked. Have they given all the information, or have they made any mistake? See, after all, what they have asked today is they have given a bundled offer and asked us to take it or leave it. Okay, that was perhaps not a good way of presenting the requirement, because WhatsApp today is not only a messaging app. It wants to get into fintech, it wants to get into insurance, it wants to get into health, insurance related activities. They are collecting sensitive personal information, financial information. WhatsApp Pay will be like a bank. Now, if that is what is going to be WhatsApp post February 2021, they should have asked for explicit consent and split their services into multiple bundles and said, if you want only messaging services, give me consent for this. If you want finance related activities, give me consent also for this, and so on. This is what every Data Protection Act does, and this is what WhatsApp failed to do. The second most important mistake which WhatsApp did was, see, we always look at privacy along with the terms of use. You cannot break the two. Now, what does WhatsApp say in terms of use and grievance redressal for a data subject or the data principal? They say, if you have a dispute with me, come to California and file a case in District Court of California. I am not going to give you an option to give any online dispute resolution or something like that. This, for to me, is the single most blunder which WhatsApp has done, and because of that reason alone, this WhatsApp policy fails the test of not only the forthcoming PDPB but the current Information Technology Act, which under section 79 has given some directions. Now, when we look at this ITA 2000 section 79, we must also understand that WhatsApp has to decide whether it wants to be an intermediary or it wants to be a data processor. Now, our section 79 in Information Technology Act provides certain concessions and um, uh, some kind of immunity only if the organization is an intermediary. Intermediary is actually an organization which is neutral to the handling of data. It only is a passage for data. If it starts analyzing the data, taking profiling out of that data and all, such an organization fails the test of intermediary, and they have to immediately come under section 43 capital A of Information Technology Act, where as a data user they have to look at reasonable security practices. Now, whether you look at 79 of ITA 2000 or 43A, grievance redressal is a key aspect of our Indian law. Today, all intermediaries websites are supposed to designate a grievance redressal officer under Information Technology Act and name that particular person and contact in the websites. Unfortunately, none of the current website owners have given any respect to this particular Information Technology Act requirement, and since we don't have a proper enforcement mechanism, nobody is asking for that. So current Information Technology Act, which talks of grievance redressal, and WhatsApp, which talks of a arbitration under the American Arbitration Act as a binding arbitration. What do we mean by binding arbitration? They will not recognize the Indian adjudication system, appellate tribunal. That is going against the Indian law straight away. And it's asking people that you have to file a case in the District Court of California, whereas I have the option to come and file a case in India. It is discriminatory, and therefore WhatsApp policy fails the test. And we can't understand why WhatsApp can give a separate policy for EU, but it cannot give a separate policy for India. Are they looking at India, which has got perhaps 400 million users of WhatsApp, as some third country, which is of no relevance to them? And I think what has happened now is WhatsApp has really given rise for all of us to think about data sovereignty, and that is why today Signal has captured some part of WhatsApp business. Telegram has captured some part of business. I would be happy if RTI captures all the 100% of WhatsApp business. That will be the Indian response to this whole aspect of WhatsApp. So I would say that WhatsApp has the right to ask for consent, but the way they have asked for the consent, where they have bound certain terms of use, they are not acceptable even under our Information Technology Act. Let us remember one thing: PDPB today is a bill, but as a bill presented in the parliament, it shows the direction in which Indian cyber law is moving. Now, what does section 79 and 43A talk about? Section 43 both talk about something called due diligence. Okay, we know that after PDPB is passed, 43A is going to be removed, which means that PDPB is a replacement of 43A, which means that PDPB is a seamless continuation of Information Technology Act, which is present for last 20 plus years. It is not going to be something new. So sitting today, if I am looking at the past Information Technology Act and the future, which is the PDPB, I look at PDPB as the due diligence under section 43A and section 79. It is to me applicable even today. If I was the certain person, I would have asked companies that please don't ignore PDPB bill. Don't wait for next 1 year for it to become a law. Please look at it as a part of the current due diligence. Now, coming to 2, 3 questions which people have asked. Why is this PDPB bill pending? 2006, there was one law which never was passed, and 20 years we have been, or 12, 13 years we have been waiting. The reason is we have found it difficult to find this balancing between the business interest, government interest, and the individual's interest. Now, today we are talking of this section uh, 35, which gives government certain powers to exempt itself. And also, so they've talked about the consent not being mandatory in certain instances. Now, what the act has done is it has definitely given certain powers to the government to exempt itself, but where? It has only given them powers to exempt itself under what has been provided under Article 19(2) of the Constitution, and even there, it has not taken all the exemptions which were available under Article 19(2), but restricted the exemptions only to the extent of national sovereignty, friendly nations, etc. So it has restricted itself, has shown great restraint. Now, not having consent for the purpose of doing some, say, giving some benefits to the citizens is part of the governance duty. Remember, after section 12, there is section 13 and 14 also, which provides exemptions from consent even for private sector. So, PDPB has given exemptions from consent to the government, to the employers under the employment requirements, and other purposes, for example, credit rating or whistleblowing, information security. So there are exemptions from consent. These are exemptions from consent, not exemptions from securing the data or misusing the data, etc. Only to get the consent. So this 12, 13, 14, if we see together, this chapter which gives powers without consent is fairly balanced. Section 35, because it gives only specific powers under Article 19(2), half of 19(2), it and also says it has to be necessary. That is, somewhere you have to have the logic of use of that particular thing. Though we discuss about what is proportional and other things, there is a provision. Okay. Now, the last point I want to make before I want Rama and others to come in, this Non-Personal Data Governance Act. Now, Personal Data Protection Act talks only about personal data. There is a definition for personal data, and it says that out of this composite data set, if you do something called anonymization, the erstwhile personal data can be considered as non-personal data. In addition, there will be certain data which will be born as non-personal data. Now, this is outside the governance of Personal Data Protection Act, because the objective of Personal Data Protection Act was privacy protection, not anything else. Now, what this NPD may do, which will be another 2, 3 years from today, is actually to help the business to make money out of non-personal data. See, non-personal data governance objective is to unlock the financial benefits with non-personal data. Now, how to do it without infringing the privacy rights? That is what will be done through the process of anonymization. Anonymization is a technology issue. Let technology people find the best of anonymization techniques. Now we talk of encryption as a security issue. Many of the data protection laws in the world, including HIPAA and others, if there is a data breach of encrypted data, it is not considered a data breach at all, because that is not considered part of the data protection. So encryption is what distinguishes between their say PHI in HIPAA and non-PHI. Now encryption can be broken by people who are putting efforts. Same way, anonymization can be broken. But because anonymization can be broken, we cannot say that anonymization cannot be recognized. Therefore, there is definitely a requirement to consider NPD Governance Act as distinct and separate from this Personal Data Protection Act, and that is what the government is proposing to do. Let us not confuse the whole world that anonymization should be part of PDPB, therefore there should be consent for anonymization. Consent for anonymization is, in my opinion, should not be done, because it is a legitimate interest of a business organization to anonymize and then make use of the data. Otherwise, you are actually restricting the positive use of data without hurting the individual. Okay. And one more point, withdrawal of consent versus right to forget. I think this was what one of the persons raised. Now, India has adopted a distinction between withdrawal of the consent and the right to forget. See, right to forget is a complete closure of any knowledge about a personal data. That is something which we should look at from the point of view of security reasons and the legitimate interest of the Indians, of the data subjects, other than the person whose data we are talking of. Indian law has correctly identified that there will be a judicial intervention before right to forget can be exercised. Of course, it's a quasi-judicial intervention. Adjudicator will be the person who will be permitting this right to forget. But withdrawal of consent is otherwise available under the current act. If I want to withdraw the consent, it is fine. But when I withdraw the consent for something which I have already accepted and done, does it affect the right of somebody else? Some say, for example, if I have got an article in which there is a defamation about XYZ, what right I have got to remove that today when, let us say, the other party wants to take a defamatory action against me? So that becomes evidence, and that evidence has to be protected. And this both ITA has 2000 has recognized, and PDPB should also recognize. So right to withdrawal of consent is accepted, but subject to an analysis of the harm it may cause to other data subjects. PDPB has thought of this, which GDPR has not thought of. Remember, we always think that whatever comes from West is great, but Indian PDPB in many ways is better than GDPR. So I think this is enough for the time. There are, of course, a lot of things. Consent manager. Okay, consent manager is another great concept in Indian PDPB, along with the sandbox arrangement, along with section 37, which gives certain exemptions, none of which GDPR actually addressed. Probably, of course, we should have done better than GDPR, because GDPR was there. If we had not taken advantage of that, we would have been fools. So what PDPB has done is, we have definitely done something better than GDPR. And if we as legal persons or techno-legal persons want to analyze PDPB, let us not simply compare it with GDPR and say this is not there in GDPR, therefore it should be bad. Data fiduciary is there in PDPB, and USCI is trying to adopt that principle. GDPR did not do it. So let us be proud of PDPB as drafted. Let us make it happen. Let there be governance. Let there be a data protection authority. which is going to be a multi-member body. GDPR has not thought of a multi-member body. There is any government official can sign a letter of appointment and appoint an ICO. India has done much more. Let us give it an opportunity. Let us look at the regulations as it comes up. Let us look at modifications, amendments which will be required later on. Then this kind of WhatsApp issues will be a passe. We will be having our own law, and perhaps we will be leading the world in terms of what should be an ideal data protection law. This is what I want to say. Back to Kritika.